The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning. Welcome to the Court of Appeals. Please be seated. All right, we're prepared to hear arguments in two cases today. We'll start with the case of United States versus Perez. Mr. Camden, we'll hear from you.
Good morning, Your Honors, and may it please the Court. Mr. Perez's conviction under 1466A should be reversed because the government failed to prove beyond a reasonable doubt through admissible evidence at trial the jurisdictional element of the crime. As alleged in the indictment, it had to prove that the pencil drawings at issue here were made and possessed within the special maritime and territorial jurisdiction of the United States. The evidence at trial was that the drawings were made and possessed in a cell at FCI Petersburg, which
Your case is premised on this presumption, this 312C presumption here that it's conclusively presumed that jurisdiction doesn't exist if you don't have the government accepts jurisdiction over it?
In a way, Your Honor, there's a threshold question of whether the property was acquired before 1940, in which case the opposite.
But ultimately what you want to, that's what's going to give you the relief, right?
Yes, Your Honor.
Well, that's my question. It's premised on this, so then we look to see, is this something that's been activated? So the before 1940, is it in 1940 where the reversion sort of happened on the Virginia statute?
So before 1940, when the United States acquired property in a state where the legislature had consented, it was automatically presumed that it acquired concurrent jurisdiction at least, right, and that special territorial
jurisdiction. This had happened before 1940. You are comfortable you would not be before us?
No, Your Honor, because the documents the government submitted here in judicial notice on appeal in its motion actually apparently show that the Virginia consent to the United States acquisition came with strings attached, and that those strings were not, that the conditions Virginia attached were actually violated, which under Parker, I believe, is the Supreme Court case allowing that practice. And so the transfer from Department of War, Department of Justice, Department of Defense to Department of Justice, starting in the 30s, and then there was in 1950 something, they finally finalized the transfer, was a different use than the use for which the property was acquired, which was...
So I mean, my colleagues have a lot of questions too, I'm sure. The legal argument you present has some force to it, but wouldn't the result be that all of the cases that have been murders and any kind of a offense that has occurred on there, since the presumption is not met, I mean, wouldn't that overturn all of them or essentially indicate that they are in question too?
No, Your Honor. There's a few different reasons. There aren't too many statutes regarding prisons that are prosecuted for crimes coming out of prisons that rely on the special territorial jurisdiction argument. In fact, 1466A, the statute here, has several different jurisdictional hooks, any of which the government could assert. In fact, they alleged a different one but didn't prove it, the commerce element. Second, statutes like 18 U.S.C. 111 apply to protect federal employees, so any assaults against staff could be punished as assaults on federal officers. There's a separate set of statutes in the 1752, I think, range, which punish contraband in prison and actually have a prison jurisdictional hook. So there are many other ways that prosecutions coming out of particular prisons can be prosecuted without resort to the special territorial jurisdiction argument.
Does the state have the opportunity to prosecute it? The state doesn't?
Absolutely. I think the most that anybody is asserting, even the government, is that the state has concurrent jurisdiction. I don't think anybody's saying that the federal government has exclusive jurisdiction over FCI Petersburg.
Concurrent means, at least when I was in the military, we would have it from time to time, mean you could get prosecuted by both.
Exactly, Your Honor. So that would be an available route to prosecution if the government were to find itself unable to establish jurisdiction.
This discussion Don't we have to decide first who makes that decision?
Yes,
I mean, the first question is the jury deciding the legal conclusion about jurisdiction? It seems like there's agreement that for the facts underlying the jurisdictional element of the offense, those have to be proven beyond a reasonable doubt to a jury. The dispute seems to be, does the conclusion about whether those facts create jurisdiction, is that something for the jury or for the court? Isn't that our threshold question?
I agree it's a question about who decides, but I think the facts, there may be a dispute about what are the facts necessary to put this place
Fair enough.
within
Yeah.
jurisdiction. So,
Okay.
what we know from the trial testimony is that FCI Petersburg is a federal prison where generally populated by
But that
inmates.
statement you just made, there may be a dispute about the facts. Doesn't that answer Judge Qualbon's questions to the effect of saying, yes, there's a jury, it would be more likely to be a jury question?
Yes, it would
That's
be a
what you're
jury.
saying?
Yes, but the specific facts when we get to this are, one, whether the property was acquired before 1940 or after. So there's a specific date, and it has to be shown whether it was before, in which case it's presumed, or after. There has to be this additional fact of an act of acceptance of jurisdiction.
Well,
Either,
why is that, are those facts, those aren't the who, what, why, where of the case. The who, what, why, where, when of the case is what your client did and where he did it. And the facts, to the extent they involve jurisdiction, this whole business of when the property was acquired, why aren't those legislative facts that courts look at and decide? Because we don't want to, I mean, it'd be unusual if, you know, one jury said this was not a, you know, within the special territorial jurisdiction of the United States in case one, and then in case two, they said, well, it was within the special territory. That'd be kind of an odd thing for something like jurisdiction. Why aren't those matters, by their very nature, legislative facts that the court would do?
to address first the possibility of inconsistent jury verdicts on a single property, it's practically unlikely, just as this court doesn't routinely see disputes about whether a particular bank, say Wells Fargo, is FDIC insured, or whether a particular gun manufacturer manufactures firearms abroad to prove the jurisdictional element for 922G cases. But really, when it comes down to it, Jackalow is the case, it's 1861, that says essentially, and that was the parallels are striking. The jury actually issued a special verdict saying, we conclude and find beyond a reasonable doubt that it occurred at this particular geographic location on this particular ship 5 miles west of whatever point. And then the court, in a lower court, a 3-judge panel had sat and trying to figure out whether that was on this side or that side, or whether it was within the territorial jurisdiction, I guess, of New York or just in the open seas. And the Supreme Court refused to decide and said, just give the jury the maps, instruct them on the law and the meaning and the construction of all of these statutes, but they have to reach the conclusion.
So if that, and I get your argument on Jackalow, and I think, you know, the government needs to talk about that. But if Jackalow is the linchpin of your position, you know, all these courts from, you know, Taylor and all the circuits that have said these are legislative fact findings, not only got the result wrong, they were looking at the wrong precedent, right?
Right.
Just all these courts and all these lawyers just missed it.
Not all of them, Your Honor. Bellow, the First Circuit
Did it
held.
rely on Jackalow?
Sorry?
Did it rely on Jackalow?
No, I don't think anybody cited it until
So
2023.
the argument you're making has not been cited by an appellate court in this context ever?
Regarding Jackalow, no. Regarding whether it's an adjudicative or legislative fact, yes, the First Circuit has concluded that it's
These are adjudicated facts.
adjudicative facts,
That's
right?
the one circuit that's done it.
Right.
Most everyone else has done the contrary.
Well, the
correct?
Second, Fifth, and Eighth are on the other side. And this court hasn't frankly come down one way or the other. that I
Although
can see.
we've embrace the Bellow standard in other contexts. We've quoted Bellow and said what really matters is how the fact is being used and not what the fact consists of.
Yes, Your Honor.
Yeah,
And that's derived from 201. When they enacted it, they made sure that this applies to adjudicative facts. And in the commentary, they distinguished between legislative facts. And the standard they set there is that legislative facts have relevance to legal reasoning and the lawmaking process. And all of the commentary after that, Professor Larson, facts used, quote, to form and apply legal rules. Judge Keaton, facts that serve as premises in the reasoned explanation of the decision of a legal issue. Professor Haley Proctor, facts required for, quote, law determination as opposed to law application.
Can I ask you a question? I understand your argument about adjudicative facts and the need for a jury to make some fact findings here, but it strikes me there's a who decides question. Is there also a when question here, kind of a temporal aspect to your argument? I mean, could one imagine a world in which you thought maybe a judge can make some, take judicial notice of some legislative facts here, but you still can't do it after the conviction and on appeal? Like if someone's going to determine whether your client is guilty or not, that has to happen at trial when your client would have the full protections that attend a trial, like discovery under Rule 16 and things like that. And we can't convict your client on appeal. I mean, for one thing, where is he? If this is his trial, if this is the proceeding that's going to determine whether or not the elements of the offense have been satisfied, I mean, isn't he supposed to be here?
Yes, Your Honor. And the exhibits would have to be introduced, and they would have to establish as...
Authenticated.
That's for a fact finder, and this court, with due respect, isn't supposed to be finding facts, it's supposed to be deciding issues of law. And I don't see a way, though, to separate out the question of whether it's just a purely legal issue, which this court, I think, could decide if it is, versus whether it's a factual issue, in which case the evidence at trial was not there, and a judgment of acquittal is the appropriate remedy. So I don't see any sort of middle ground for a remedy involving a remand or a new trial. I think it would be forbidden by Burks and the double jeopardy clause.
Yeah, I was just trying to figure out how much we have to decide in this case. But, yeah, okay.
I think in this case, the trial evidence was, this is FCI Petersburg, there are federal inmates
Well,
serving
I
federal...
understand your argument that this was not proven at trial. I'm just trying to figure out, because as I read Burroughs, our decision in Burroughs, we seem to contemplate in that case, look, had you asked the trial judge to take judicial notice of these facts, that might have done the trick. It's just that you didn't, and we're not going to do it for you on appeal.
And that would be what the First Circuit did in Bellow. It actually was judicial notice, but it was under Rule 201, and they affirmed because the trial court had meticulously followed Rule 201F, now it's F, it was G, that instructs a jury in a criminal case that they don't have to, under Sandstrom, that they don't have to take the notice fact as conclusive. So it still leaves, it doesn't infringe on the jury's fact-finding role in that case. And that's a separate, there was a waiver of jury trial in this case, so that would be a separate issue for a separate case. But it appears that there's a good argument that 201 respects the jury's role, even while allowing a trial court to take judicial notice of these facts.
So how does this relate, the notion that we don't find facts is certainly true in one sense, but is it true on legislative fact-finding?
No, Your Honor, so the court's absolutely
If
true.
we're in the legislative fact-finding role, you agree, don't you, that, trial courts, appellate courts, the Supreme Court do that, with some frequency?
Absolutely, they're doing it right now. I think there's that big case involving the treatment or the restrictions on medical procedures on children and trans rights, and the court has to find all sorts of facts in order to...
Yeah, sorry, I just want to, I find this case I find it actually very conceptually difficult. Is it common is it common in criminal cases? I know that there are these old cases where courts do appear to take judicial notice of an element of the crime, of the jurisdictional hook. Is that common?
No, it's impossible, especially since Apprendi, but I think even since In re Winship, it says every element of the crime must be proven beyond a reasonable doubt at trial to a jury. There was some sort of confusing these jurisdictional elements with issues like venue, which venue does only have to be proven, or venue isn't an element, essentially. And the Supreme Court just decided that this last term.
That's what Jackalope was.
Right, exactly. And so the Supreme Court said when a jury acquits because of lack of venue, you can retry the person.
Well, why is this not, I mean, we have criminal gun cases that now are being challenged under Bruin. And, you know, the Second Amendment defense, at least, is subject to legislative fact-finding concerning history and tradition, isn't it?
Yes, and those are all to get back to Judge Harris's question before my time runs out about what the Second Amendment means. They're about the interpretation of they're upstream of the question of what does this law mean. There's no dispute here, and I see my time is running out. And
All
I'll
right,
be happy.
Mr. Cameron, we've got a few minutes in rebuttal, so we'll be hearing back from you again.
Thank you.
Mr. Nguyen with an I, you're next.
Good morning, Your Honors, and may it please the Court. Connor Nguyen for the United States. As Judge Quattlebaum acknowledged, there are two questions in this case. The first is a methodological one, and the second is a follow-on legal question if this court concludes that it may take judicial notice and decide as a matter of law the jurisdictional status of FCI Petersburg. I want to walk through those two questions one at a time and explain why this court should affirm, and to address Judge Harris's conceptual challenges with this case, because I agree this is dense. So to start with the methodological question, which I think is the denser question here, at least from a legal point of view. So the way that Section 7.3 works, it's a subsection of a statute that defines a number of places throughout the United States that Congress has legislative jurisdiction over and has acquired jurisdiction over through two constitutional processes, state consent or session.
I'm so sorry.
Yes.
Can I ask you, actually, I hate to interrupt, but I just wonder, it would help my conceptual confusion if we could kind of start with what happened at this trial.
Sure.
Because it seems like at trial, the government was under the impression that it did have to prove up jurisdiction to the jury, right? Because you called a witness to prove that well, first of all, to prove that the copier moved in foreign commerce, which I guess would be a legislative fact on your understanding, because that is just a fact about the world that is not dependent on what happened in this case, and it would be weird if you had two different jury verdicts about whether this copier. So you were prepared to prove up that legislative fact, and you were also prepared to prove up the special territorial jurisdiction of the prison. It's just that you did it under the wrong standard. So I feel like we're in this weird situation where at trial, yeah, of course, you have to prove this stuff to a jury. That's what a trial is for. And you just messed up. Like you brought in the wrong barcode for the copier and you used the wrong standard for special jurisdiction. So how is that not the end of the case?
So I think specifically what's relevant here is the district court's finding on the special territorial jurisdiction point. And you can see this in JA 120.
Do you think the district court was right? And if so, what's with the new 300 documents? It doesn't look like you're asking me to affirm the district court's finding. You want us to make a brand new one based on an additional, I can't do the math, but many documents.
So I do think that the district court was correct. I think its baseline legal ruling is right, that FCI Petersburg lies within the jurisdiction of the United States. Now, it based that on legal cases that I don't think on their own fully answer that question. But its legal ruling is actually correct. And so what's no different here
Right, but do you think that the 3 documents you submitted at the motion for acquittal stage are sufficient to prove this element? And if so, why did you give me 300 new ones?
Right. So I think the document at JA, I believe it's 168, the one that's showing the Attorney General ordered the creation of the prison on the Camp Lee military grounds, I do think that one's enough to show that the prison that became FCI Petersburg was established before 1940 as necessary for the federal government to presumptively have accepted jurisdiction under 3112. So I actually think that that document is on its own enough. We've added these documents, which are noticeable by this court because they represent legislative facts going to the jurisdictional status of FCI Petersburg, to give this court a more comprehensive understanding of exactly why that is the case. Now, I think going to how the district court went about resolving this issue here, Judge Harris. You can see on JA 12728 its findings on this point. The first thing that it does is it says, Mr. Perez's crime occurred in FCI Petersburg. That's finding the purely factual component as to where his crime occurred. The next thing it does on those pages is it rules that as a matter of law, FCI Petersburg lies within the United States territorial jurisdiction. That's its legal ruling. And then what it does is it applies that legal ruling to the fact at hand where Mr. Perez's offense occurred. So it's applying laws to facts as fact finders ultimately do. And that's when it says that, and it concludes on JA 128, that his offense occurred within the special territorial of the jurisdiction of the United States. Now that's...
So
yes.
I think I understand, although I wrestle with, but I think I understand your argument. But why did the government try to prove these up as facts for, it wasn't the jury, but for the fact finder at this bench trial? I mean, is that just something you do like belt and suspenders? We don't have to do this. We could just do this as a matter of judicial notice, but we're going to go ahead. Like I do all those 922G cases, you know,
Sure.
and the government's always trying to prove up where the gun was manufactured, which again, a fact about the world,
Right.
not the who, what, where. Just, it would be weird if two different juries came to different conclusions about where a gun was manufactured, but is that all just kind of like, we don't have to do that, but we do it anyway?
So the gun example might be a little different because 922G cases are about a specific gun, right? Maybe you might, like as a legislative fact, it might, for example, a Springfield firearm, it could be taken as a legislative fact that those are made in
I think it would be. It would be
Right.
very weird if there were two prosecutions, two people who owned the same gun, and in one jury found it was not manufactured in Connecticut and one found that it was. That would be very weird.
Right, that would be strange. And I don't think...
So why do you guys try to prove that up in every case? And is that, if we agree with you, are we now saying, good news, the government no longer has to prove that the gun moved across state lines?
You know, I would want to go look at 922G's. I would want to look at 922G's language very carefully before I made a representation to that effect, because how this plays out in every federal statute is different. The jurisdictional
It
elements
would
of...
certainly be raising that question, right? It would, if we agree with you in this case, we have now, it will be an interesting question whether the government going forward still needs to prove where these guns were manufactured.
Potentially, I think it would be a little bit similar at worst to what happened in Taylor, the Supreme Court's decision with the Hobbs Act attempted robbery of a marijuana dealer. Prior to that decision, two circuits had in fact suggested that the district court had some burden of proof to prove an actual effect on interstate commerce was implicated by marijuana dealing, and the Supreme Court said, no, that is not correct. And to talk a little bit about how it works with this statute and bringing us back to Section 7.3 specifically, because this statute stands on its own terms. So I think what's really helpful to understand about this statute is that Section 7.3 is what I'm going to call a statutory shorthand. Congress could have, instead of using that language, listed every single place within the United States that falls under its legislative authority due to the Enclave Clause or state session. It could have done that, but that's an impractical way to write a statute. So instead what it did is it used the language in 7.3 to describe those places, much as in Section 924C, for example, it uses the phrase crime of violence to encompass, and the statutory definition used there, to refer to a host of state and federal crimes rather than listing them out one by one. That is the exact same way that Section 7.3 is working. And what Congress is counting on is that courts, such as this one, will look at Section 7.3 and apply those general principles and language to determine which places Congress is in fact talking about, the places that are within the special territorial jurisdiction of the United States. Now, once that is done, once a court has concluded whether a place in fact meets that definition, here's how this works for a fact finder. At a trial, the fact finder must find the place of the defendant's offense. The district court will then instruct a jury, assuming there's a jury, or in a bench trial like this case, the district court just makes its legal ruling, that a given place, in this case FCI Petersburg, is within the United States special territorial jurisdiction. Then to apply that law to the facts, what a fact finder does is it takes its factual finding where the offense occurred, and it takes the district court's legal ruling and then says, did Mr. Perez's crime occur within the special territorial jurisdiction of the United States? That is the law, the facts, and the application of facts to law, as happens in every case for every
So you're
element.
saying it's like a Major Crimes Act case?
It's exactly similar. In fact, I think it's very telling. We cite to McGirt, obviously. I think if this court were to embrace Mr. Perez's position in this case, that would call into question whether or not a jury needs to start weighing in on whether crimes involving major crimes cases.
But do rely on treaties and legislative acts here.
Certainly,
And
yes.
was interesting to me that all these years, this case is coming up, you know, because there've been a lot of crimes committed there. All of a sudden, we get this case, which I would tell you on both sides, these briefs are really good, part of both of you. But let me ask you a question that, of all we've talked about, was the initial intention of Virginia in giving this land to the federal government for it to be a military camp?
Yes, well, at the time the lands were originally acquired, that is correct, in
And
1918
Virginia, before
22.
then, didn't it have some kind of statute, a reversionary type statute that says if you change the use of this, it becomes ours again? I mean, North Carolina's got something like that dealing with railroads for people, which I think is pretty cool for when you give up your land for a railroad and it ceases to be used.
Right.
The landowners 40 years from now can all of a sudden find themselves with quite a prize. I'm
Right.
not sure many people know that, so they're probably listening right now. But isn't there a reversionary statute here?
So since we've turned to kind of what I'll call the second question, the true legal merits question here, let me
I
talk
don't
about
want to turn you
this.
for the first one, but that's an intriguing argument on my part. Is the fact that Virginia gave it to be a military camp. Virginia has a reversionary statute, so when you change it, and they change it to a correctional center, sometimes I guess in the 40s or whatever, and then that's where I saw that little statute with the C in it that kicks in and says, well, government's got to accept it. And it sounds like it's perfunctory, but that's a pretty strong piece of language there that it leads to.
Yes, Your Honor. So Virginia law is evolving a lot in this period of time, and the portion of Virginia law relating to consent and cession that you're talking about actually did not apply to these particular properties. And let me walk through kind of like...
Portion of the reversionary.
Yeah, that reversion clause had no effect, and even if it did, there's an alternative argument for why it didn't matter here, and let me walk this court through that. So the reversionary clause that you're talking about comes from Virginia's general consent statute, as it existed, I believe, on March 4th, 1918, and you can see that on page 84. Then on March 18th, 1918, Virginia passed a revision to its general consent and cession statute, and that's the one, and in doing so, you can see, this is on page A10, I believe. Yes, it begins on A10, and on A11, it repeals the prior version of its general consent statute. And in A11, the one that's in effect as of March 16th, 1918, and that will then go on to govern the acquisition of the lands underlying Camp Lee, there is one condition on the United States persisting jurisdiction over those lands, that is that it shall continue to own or occupy. This act, which replaces the prior one, no longer contains a condition providing that it must be used for the original purpose granted. Now, that law remains in effect until 1936, when Virginia again revises its general consent statute.
So, counsel, let me just jump in. I want to let you finish your analysis, but what you're doing now, creates an issue for me. Look, we may follow that, and agree with you, but we're doing a lot of detailed work here that the district court didn't have the documents to do, didn't do. It seems like to me, we have this first question, which is this for the court or for the jury? And for you to win, it's got to be for the court.
Yes.
And we talked about that a little bit so far. And I think if as a matter of principle, you're right that appellate courts can fact find legislatively, so that's what you're asking us to do. But on the other hand, we've said a bunch of times we're really a reviewing court, more so than a district, a court that finds facts in the first instance. Maybe even that's the best way to do legislative fact finding. So why wouldn't we if you're right on the first question, why wouldn't we send this back so the district court could make sure it has all these documents from which to find legislative facts and do this analysis and us review it?
Because what we're talking about here is a pure question of law, and that is emphatically this court's domain. For example, if the district court ruled in a case implicating Bruin, which I heard you say earlier, just said, I believe that 922G1 is constitutional, didn't do any sort of analysis into the Second Amendment history that's now necessary in those cases, this court could certainly do the Second Amendment analysis on its own.
I didn't mean to suggest we can't. I'm just wondering whether, if you're right on the first question, whether we should do this in the first instance or whether we should send it back for the district court to do it. One of the things about legislative fact-finding is making sure you have all the legislative facts so you're not missing something. Now, you gave 3 documents at trial. Now we have a lot. I'm not suggesting there's anything untoward with that, but there's a question of, is this even the full universe of documents that represent the issues here? And, one of the criticisms of courts doing legislative fact-finding is that they cherry pick. Well, no one's suggesting we cherry pick, but whoever does this seems like we need to be assured we have everything. And I'm just concerned about that.
So 2 points on that, Your Honor. To your concern that maybe there isn't everything, Mr. Perez has had the same opportunity that the government has had here to offer for judicial notice of this court any relevant legislative facts.
Can I just stop you there, because this does dovetail with a concern of mine. So, when this is an element of the offense, if you have to prove it up at trial, there's Rule 16 discovery, there's a lot of time. I mean, you dropped 300 documents attached to your response brief on appeal. The defendant had, I don't know how many weeks it is, but it's quick between a response brief and a reply brief, and 4 pages in a reply brief to respond. That is not normally how this works to prove an offense, to prove an element of a criminal offense. We don't tell defendants, the government's not allowed to say, you'll find out what documents we're relying on when we submit our brief, and then good news, you'll have 2 weeks to write a reply brief. That is not how this is supposed to work.
So, Your Honor, a couple of things. I think if we were talking about the factual component of Section 7.3, yes, I hear you. I agree. There's rights to discovery in that regards.
But there are. I thought you had sort of conceded that there were at least legislative facts that have to be found. When did this stuff happen?
Right. So I don't think that the legislative facts are found in the way that we normally use that term, right? Legislative facts are things that courts rely on in announcing, in declaring what the law is. So in declaring what Section 7.3 means.
Okay, so we have to rely on certain legislative facts.
Certainly, that's
Okay.
true. But I think that's true.
Without finding them?
Yes, but I think that's true anytime this court is announcing the meaning of constitutional provisions or
Yeah,
statutes.
but we're not usually doing that in order to decide that an element of the offense has been satisfied. This is an unusual context to be doing that in, and that is why I am worried about usually when someone is deciding, have the elements of the offense been satisfied so that this person is guilty of a crime, they're doing that in the context of a set of procedural protections that ensure that the defendant is going to have time to rebut any case the government thinks it can make.
So it feels unusual, and I understand that just because of the nature of Section 7.3. Section 7.3, right, is in a way concerned with historical facts, which are legislative facts, but they're historical in the big history sense of the word. So that it's unusual in that sense, but I don't think the actual activity of what the courts are doing is unusual. For example, in the Commerce Clause context, if this court were asked whether or not there's an interstate effect on commerce due to banking, for example, this court would have to rely on a series of legislative facts to conclude that there is, in fact, such an interstate effect on commerce, right? The volume of financial transactions that happen, the fact that they cross borders.
Case law. Okay.
Right, but I mean...
I don't think we would have to do legislative fact-finding. We kind of know the court has already laid out the standard on reach and cases like that. We just apply
Sure.
that.
Yeah, but it's applying a standard to legislative facts about a particular industry to determine whether or not there's Commerce
Can I
Clause.
just ask you, sorry,
Yes.
I'm going to take you a little bit afield for a second. Just what happened with the copier in this case? Is it possible that you are looking at the one photocopier that was not manufactured outside this country?
Yeah, well, my understanding is that, defense counsel challenged whether or not the copier was in fact manufactured outside the country, and the district court found his challenge persuasive and said, no, the copier doesn't appear to have traveled in interstate commerce. And, in that...
They found a tray or something attached to it.
Right, the
Yeah.
document feeder, because that's what you guys
Right.
proved up by mistake.
Yeah, and the district court acquitted on that ground, and we haven't appealed that.
I'm just wondering, because it does seem to me that these 300 pages, just going back to Judge Quattlebaum's point, you're asking us, I mean, it's a lot to take judicial notice slash reliance slash find these facts. It's complicated. It's not an obvious thing. Why not? I'm just sort of surprised that you didn't, assuming you can just keep trying as many times as you want to prove this element, why not just come here and say, please take judicial notice of the fact that this copier was manufactured outside the country? Because that would be a legislative fact under your kind of rubric.
I think that's a little bit different because it's the copier that was literally used in this particular case for the production of the images, and Mr. Perez's crimes are about production, right? That relates to his crime in
Well,
a...
so does where he committed. I really don't see that distinction. I thought you would say it is a unchanging fact about the world where this copier was made. If two prisoners are charged with this kind of morphed child pornography, it would be very strange if one jury concluded the copier did move in foreign commerce and one jury concluded it didn't. Like, this is supposed to be an unchanging, established fact
Sure.
that cuts across cases.
Sure.
And it just seems like we could do, it just seems like it would have been so much easier. You wouldn't need 300 documents.
Maybe so, but the district court acquitted, and, you know, acquittals are the government didn't cross appeal from that, right? So, I mean, I'm not to say that that's not before this court. It's not really, it's
Oh,
not
I
on
know
the
it's
table.
not. I'm just wondering why it wouldn't have been a lot.
Yeah, and I take the point, Your Honor. I see that my time has expired. I'm happy to answer any other questions about this case if the
Well, as
court
I
wishes.
said, the briefs in this case is really, really good. You guys have done a great job on it, and we could probably spend the rest of the day talking this case through. There are a lot of aspects to it, but we're just not going to do that right now. Thank you, Mr. Nguyen, for
And
your argument.
I understand, and I would ask that this court affirm.
All right. Mr. Cannon, you've got a few minutes in rebuttal.
I'll try to be succinct and focus on whatever the court is most interested in, I think.
Let me ask this question regarding the question Judge Quattlebaum posed. I thought you basically argued that there's no avenue for a remand on any portion, whether the second part of it or the first part of it.
That's correct, Your Honor.
So you don't think that if we go with the first part of this analysis, there's no reason for a remand?
That's correct, Your Honor. I think a remand would not be forbidden in order for the district court to have a first bite at if the court determines it's a legal
I don't
question.
normally hear a defendant say that. Sounds like to me, if he can get any kind of remedy, he would take it, even if it's a remand. But, you know, to say, no, don't do it if you get the first one, and I get your point in terms of why you're going there. You're probably analyzing it from a legal perspective, saying it doesn't really mesh up once we get back there and start looking at the real deal on it. But just want to get that point clear, because it seemed odd that you are saying no remand, which means no relief if we go with the first part.
And ordinarily, I would welcome any kind of remand, but honestly, Mr. Perez is already serving this 15-year sentence for drawing pictures. The evidence at trial was insufficient, and Burks says double jeopardy forbids a remand for additional fact-finding or for a second bite at the apple to try to prove an element that wasn't proven at trial. If the court does determine this is a legal question, then it could determine it itself, or it could remand to the district court just to determine the legal question in the first instance. That seems like a rare occasion, but it certainly wouldn't be forbidden, and we wouldn't object to that. But I think the first question the court would have to determine is this a question of law or a question of fact? And FCI Peters, maybe prisons in general, or the meaning of Section 7.3 are legal questions, but whether those requirements were satisfied as to a particular piece of property with particular transfer dates and particular use is just a question of fact. The government, and I think the government's right, Section 7.3 is shorthand, and it doesn't list specific
So
properties.
as you understand how this trial should work, the government should have put these statutes and these deeds and would be making decisions about whether it reverted back or didn't revert back. That's what you would have the jury do in this case, get these 300 documents and decide whether the federal government acquired the land, B, did the state consent or cede to either concurrent or exclusive jurisdiction, and see that the federal government accepted jurisdiction. We'd actually be submitting that to the jury. That's how you say this trial should have gone?
Not all of it, Your Honor. The statutes are, in their meaning, are a matter of law for the court. So we wouldn't have to give them the statutes. It could instruct them, here's what the law says. But the factual determinations under that law that place this property within that definition or outside of it would be, one, whether or not the property was acquired before 1940 or after, and two, here's what Virginia said about its consent statute, and you've got to determine whether its use of that, whether that's the use of the property was inside or outside that scope of that state's consent. So, not all of it. I think the court would, statutes, we agree, are legislative facts. The court can always judicially notice
Those
those
things are all
statutes.
commingled in this decision about whether there's special territorial jurisdiction here.
Well, a lot of statutes list specific geographic locations. The one establishing the Eastern District of Virginia
Right.
lists the counties that constitute it. The treaty with the creeks at issue in McGirt lists meets and bounds the actual location that you can draw on a map of a place. But Section 7 doesn't do that. It lists these broad categories. The plain in certain circumstances and places belonging to certain countries. As far back as 1820, we cited a case where the Supreme Court said the national character of a ship is an issue for the jury to determine on whatever evidence will satisfy it as to that. So the facts that place a particular property within this definition are factual findings, not legislative facts. Legislative facts are about what the statute means or what is the scope of Congress's power under the Commerce Clause. And that's what Raich was about. There were no fact-finding in Raich. It was a rational basis test with legislative findings. The Supreme Court said, does Congress, we're not even saying whether the production in this case of marijuana affects interstate commerce, because we're finding that there was a rational basis for Congress to conclude that. And in Taylor, it wasn't about whether it actually affected interstate commerce. It was about the scope of the law. What is Congress's power here? And we have no disagreement. I apologize, I'm beyond my time, but there's no disagreement on the law.
Thank you very
here,
much.
just the
But
facts.
This is a very dense case. It's been indicated. The two of you have given us difficult decision, but that's what we do up here. We will do it. We're going to come down, greet counsel, and proceed to the next case.
I can get it. It's okay, I can just jump over the arm. It's really small.
So, you know what? Sit in. Sit in. There you go. Little technical difficulties up here for the judges. All right, we'll go to the second case on the calendar for today. That's the Edwards versus CSX. And we will hear from you, Mr. Cash.
Well, that's me. I'm Bill Cash III, representing Jimmy Edwards and the Lumberton plaintiffs, and may it please the court. So we've raised 3 issues on appeal, and they are ICTA preemption, the plaintiffs standing as third-party beneficiaries, and the condition precedent issue.
So we had this case before. Thought it might be the last we will see of this case, but here you are back again.
Yes, sir.
And so, okay, proceed. Tell us why you think things didn't go right on the second go-around with this.
Well, we think the court committed all 3 of these legal errors on these particular issues. Then the bulk of our argument, I think, will be on ICTA preemption, and I'd like to go there first unless the court has other burning concerns. So this panel set out correctly the law of implied preemption under ICTA, and the law is that a local regulation, such as the voluntary agreement it entered into below, is preempted if it has an unreasonable burden on interstate commerce. And this panel has said that a regulation does have an unreasonable burden if the burdens imposed on the rail carrier outweigh the local benefits provided by the regulation.
Could you repeat what you just said?
Sure. Under PCS phosphate, the controlling case here, the regulation is viewed as being unreasonably burdensome on interstate commerce if the benefits, the burdens imposed on the rail carrier are not outweighed by the local benefits that the regulation provides.
Well, that's not, I mean, that case decided express preemption. That's how it was, I mean, the one that, I mean, I know it talked about how there could be implied preemption that laid out some law, but the holding in that case was not on implied, was it?
I believe it was, Your Honor.
You do? Okay.
Is that the Pike case we're talking about?
The PCS phosphate case, and Pike is cited to in that case as the source for the local benefits test. And I acknowledge that's a dispute between CSX and us as to whether this court should take into consideration the local benefits or not. But the court has stated that is the test, that the local benefits do weigh into the analysis.
But Counsel, can I ask you a question? Because I find this one so tricky. So we're in the implied preemption box. We said that in our first Edwards case. But we also said in Edwards that what's at issue here is direct regulation of railroad transport. But that's what the enforcement of the agreement would mean. Like you're basically shutting down the railroad. And so this is about direct regulation. And so I feel like we're kind of in this weird space because if in fact this is about direct regulation of rail transport, and we said that in Edwards, isn't that kind of per se unreasonable? How could we say that could possibly be a form of reasonable regulation of a railroad when we know cities can't do that? Do you see what I'm saying? I feel like we're in this weird space because normally we would think of this as an express preemption case, but it's a private agreement, so we said in Edwards, if it's preempted at all, it has to be implied. But we also said this is a city trying to, enforcement of this agreement would literally shut down a railroad for some period of time. So that's direct regulation. And I don't understand how kind of consistent with the basic preemptive scope at issue here, we could say, well, but if there are really countervailing benefits to the city, then it's okay to regulate whether or not these railroads stay open.
I think I have a couple answers to that. And so I think one thing that would be relevant is to look back at the historic legacy of railroad regulation in the country since the 1880s. And the concern all the way back then was that states would engage in protectionism on purely economic grounds, like changing fares, changing tariffs, putting special taxes on the railroad just because it's the railroad, attacking the products from one state that are being shipped through my state to another state where I'm not really deriving
So if
the
this were
benefit.
that.
None
if
of that
this-
is happening.
Right, but if this were a private agreement that, say, purported to attach some fee to a railroad every time it went through town, you would say that that is impliedly preempted because that would be unreasonable?
I would draw the court's attention to the Township of Woodridge
Well, I
case.
guess before you do that, can you just say yes or no? Would you say that is impliedly preempted as unreasonable?
Can you state the hypothesis again?
The city forms an agreement with the railroad that every time a train comes through town, the city will be paid $100.
I'm waffling to answer that clearly because I think the fact, if a railroad actually entered into a voluntary agreement like that with a city, I think you would be in Township of Woodbridge category. And that case, as also followed by the Fourth Circuit, says that a voluntary agreement that a carrier has entered into is almost always not preempted.
Okay, but just a second ago, you said if I go back to the 1880s and figure out like what is really the point of this whole preemptive edifice, it's about stopping cities from doing things like that. So how could that possibly be reasonable?
I guess we could conclude that that would not be a reasonable regulation to impose.
Well,
But-
why would you say that? Why wouldn't you just say that if an entity like a railroad voluntarily enters a contract, you know, it's not a regulation, it's a voluntary decision, And it's not unreasonable because it agreed to the benefits and the burdens of it. And now it wants, seems to me your argument would be, you don't get to enjoy the benefits of a contract, and then when you have the burdens, claim it's a regulation that was imposed on you. Why wouldn't that be your argument?
That is our argument, and that is the Township of Woodbridge line of analysis, that you know, a voluntary agreement entered into by a carrier almost never can be considered to be unreasonably burdensome on rail transportation and on the carrier, because the carrier got the ability to go and decide if they're going to enter into that agreement. And if that agreement was truly unreasonably burdensome on the carrier wouldn't have entered into it.
What does it matter here that that agreement had the business of setting up those dikes, as I understand it? You got these dikes, and if you have those dikes, correct me, and make sure I understand this, because I'm also pulling on the way I heard this case the first time. And you got the dikes there, then you can close them pretty quickly. But if you got to build them every time and do everything up, that's a different type of interference. Of course, Judge Boyle said that was a condition precedent. Whether it is or not is part of the voluntary agreement. And that necessarily implicates the question of whether this is unreasonable interference. I mean, if you got dikes there, if you can close, I would assume in a matter of minutes, boom, you can do that. You can probably do it on short notice. We hear a flood, the river, something is flooding. Lumberton is loaded with wonderful places to flood down there. And, you know, that's an unfortunate situation here, but a good reason. But you could close it real quick. But if you got to go put sandbags down and build it up, and there's a lot of, you know, other things have to happen, that's different. Don't you think that materially changed that voluntary agreement?
No, we don't think that there actually was.
Why didn't they comply with it? I know it's been a long time. You wouldn't know that. Might have been money. It might have just been the fact that they didn't need them because nobody asked for them after. But why?
The record really doesn't speak to why the city didn't build the dikes that were specified in the tri-party agreement. But I think the district court was wrong to essentially import the license to build those dikes into a condition proceeding.
Well, maybe it's, as Judge Wynn says, maybe it's not technically a condition precedent, because it doesn't say, you know, as soon as or after or something like that. But this is kind of I think the law in North Carolina tells us that if you're claiming a third-party beneficiary, you know, contracts are strictly construed. And aren't you basically asking us, it seems like what the claim is that the city or the railroad didn't agree to this last-minute temporary barrier in this area.
Well, the barrier was always contemplated to be temporary.
Well, the barrier was, but the agreement was that the city would be, as Judge Wynn said, the city has the right to build this earthen dike with a lot of detail in it. Didn't say, you know, create some barrier of whatever means it thinks is best given the circumstances. It's pretty detailed. I don't have any idea why they put that level of detail in there, but that's what the contract says, and it's pretty clear that didn't happen. So I guess my question is, if you want to claim contractual rights to an agreement, is claiming that the railroad should have agreed to this temporary thing right before the storm something different than claiming a right under agreement that involved a 6-foot earthen dike?
We don't see it that way because, first of all, there was sufficient time to put the full barrier, the temporary barrier that CSX ultimately permitted at the very end during the second storm, the one that partially failed.
That wasn't, if that had happened and was done, we have something different than what the contract called for.
Well, I think it's also relevant that CSX actually performed under the agreement during the 2003 to 2005 time period and did permit the city to invade the crossing and didn't complain at the time.
It seems that Judge Qualman's question is going to, if you're going to rely on the contract, we look at the contract and we determine the language in it, and determine what part of it is violated and what part has been followed.
And-
But the follow-up part about it that you seem to be going to is, well, these are importing other principles, equitable principles or something else that, they should have done this, or they ratified it in a different way by allowing you to do other things. I mean, to me, that's sort of different. But initially, you have to admit it does not strictly follow that contract by not doing it. But then you might import some other basis upon which to say, nonetheless, we should be allowed to do this.
I can't accept that or concede that, Judge Wynn, and that's because the contract does not require the building of the earthen dike. And if it did, that would be a condition precedent inherent in the contract. The conditions precedent are clearly disfavored in the law, and they're found only when the clear and plain language of the contract actually shows consent and the need to have that. Also, CSX didn't suffer from the cities not building the dikes. It didn't cost them any profits. It didn't impose any.
Well, what does that matter? I mean, I think you have a pretty good argument that it's not technically a condition precedent. But let me just
I'm
get
sorry,
the
Your Honor.
question out so you know what I'm asking.
Yes, sir.
But throughout the agreement, it uses the term said dike. I mean, in every single paragraph, 1 through 9, including 8A. And said dike, as a matter of just pure contract, can only be the dike that's in the witness of the paragraph. It has a lot of detail to it. And, they could have, and maybe this is hyper-technical. I'm trying to figure out, or is this too technical an argument? But, it would have been easy to write this to say that the city has the right to, build some barrier of any form it deems appropriate to resist floods, and the railroad will consent to closing that up, upon notice. But for some reason, it's got this extraordinary level of detail, and you seem to want to enforce an agreement that's different than the one that's in writing.
I guess it would turn on whether the construction of the dikes truly was required by the contract or not. And there's nothing in the contract that says expressly that before CSX has to permit closure of any part of the crossing, the city has to go ahead and build the dike first. It just doesn't say
Help me
that.
out at least in understanding, because I'm thinking also, contract must have definite and certain terms. And if you include part of that, said dike is just said dike, isn't there something that says if you have a dike there, it works more efficiently or quicker than the method by which you want them to go now, sandbagging and putting other structures there, for which you don't know the time, and the lead time of doing it, if you know there's a hurricane coming, in this instance, it might be a week you want to start doing it, which would shut down the railroad for a week, whereas would a dike have shortened that time period?
Potentially so.
And potentially by what? How long would it take? Is it simply closing the dike?
No, there still would be a need to lay sandbags between dike A and dike B to fill up the gap.
But it would
So that would still-
create this opportunity to do it in a structured way quicker.
Definitely.
So why isn't that a material term under the contract? When you think about it, when you talk about unreasonable interruption, and you make a contract and you say, okay, we're gonna build these dikes up here on the side, well, we know it's only gonna take a certain period of time to do that. But if you just say, we're gonna put out bags and you don't know, and you need a week to do it, and then you got their allegations, Lumberton's out there somewhere not far from Fort Liberty and all these other military installations in North Carolina, and they're under this particular act that deals with moving military supplies and all kinds of stuff. There's a lot packed in that, but my question really goes to the question of the importance of the contract itself. And I agree with Judge Qualibon, it's difficult to see it as a condition preceded, but it certainly is fundamental under that contract, and it could be in terms of how you would view temporalness. definite uncertainty in terms of saying, we understand, we'll have a meeting of the minds, which is what a contract is really about. We are together on this. If you're gonna do this, it's not gonna take but a little time to do this, or whatever time, we're good with it. But if, but if you're just gonna have a system where it might take a week or so to set up, that's a different ballgame.
But, Your Honor, that's a classic factual determination that a jury could have made. So if the argument from CSX will be that it would be unreasonable to enforce this agreement that we made, that we knew we were going to be living with for decades, because it's a few extra days to close the berm, if that's the argument, and that that's the reason it makes it unreasonable, those are disputed facts between the parties.
It almost seems like if you tell me it's gonna be a few extra days that a railroad cannot operate, and then you tack with it these other responsibilities the railroad has, because a lot of stuff moved on that railroad, that difference, it just seems almost, as a matter of law, that's kind of material, this contract, or at least it seems like it's pretty strong as a basis under that contract that would say, no, this is not being followed in the manner in which it was agreed to.
Well, if I may answer
Please,
that question. We don't concede that it's a condition precedent in the contract. And if the city's delay, I guess, in taking too long to close that gap is material, that is a fact question a jury should have resolved. This agreement imposed burdens on CSX only 27 days out of the 16,000 that it was in force.
All right,
And even of
let's hear
those,
from the other side. You've got some time, you'll come back and talk to us, so give you time to reflect on some of these questions.
Thank you, Your Honor.
Yep. Mr. Winkleman, did I get that right?
You got it right, Your Honor.
Good. It's your time.
Good morning. May it please the court. In remanding this case in 2020, Your Honors put us to work. You said, paraphrasing of course, that the preemption question might still be in play. Number one, you said two, there needed to be evidence of intent on the third-party beneficiary question.
Like the trial judge the first time said it wasn't preempted by, then he changed his mind.
Well, that's right. In fairness to Judge Boyle, we did not present implied preemption to Judge Boyle, but everything you said, Judge Wynn, is correct. So that's point two. And then point three, you said on condition precedent, CSX would be free to pursue that on remand. So we did that work. And I'm like, I listened intently to the argument before about whether evidence was new to you. It's not here. In this case, we went to work for a year and a half and took, exchanged about 5,000 documents, 20 fact witness depositions, expert depositions, and the court resolved 3 questions, all of which the appellants now have to overturn in order to win. And the whole case boils down to, and I'll quote Your Honor, Judge Wynn, this morning, to the importance of the contract itself. And Judge Quattlebaum did my work for me. This contract does one thing.
Why'd you all of a sudden decide to enforce it? You've been doing this for decades.
I'm sorry?
Do this. You've been letting them do this for decades. Why now?
Yeah, there actually has been no enforcement, Your Honor. The reason there's been no enforcement is because this contract lets city government do one thing, just as you said. It lets city government, if it wants to build an earthen dike, come on CSX property and build a dike. And in its wisdom, I'm sorry, please.
Yeah, and we kind of, I know you appreciate your argument, they didn't do it, you made that, but, and, I pressed the other side on this point. On the flip side, does it matter that what they plan to do in these 16 and 18 was, if anything, less burdensome on the railroad than the earthen dike would be?
Your Honor, it does matter in the sense that what CSX does for a living is cooperate with local government, and that's what it was doing here, and that's what it does with the city of Lumberton and has for all the 46 years since this contract was entered into. The rest of the answer, Your Honor, is it doesn't matter at all to this case. Because-
Why not? Contract law, and maybe it doesn't ultimately matter, maybe it does, but contract law has principles like substantial performance and de minimis sort of violations. And, you know, if they had put a concrete barrier that might have interfered with the railroad and its operations and maintenance, I get that. But I would think that the railroad could really care less that it's a less intrusive barrier than a more intrusive barrier. So it seems like this is a very, maybe correct, maybe it ultimately prevails, but extremely technical argument that, you know, that you're claiming the city, which had a right to build the dike, not an obligation, a right.
Correct.
You know, it didn't do it, it came out with a temporary thing that would be less burdensome. Is there a contractual principle like, that substantial performance or de minimis violation that inures to the benefit of the plaintiffs?
I couldn't agree more, Your Honor. There is a substantial performance doctrine. It has to be performance of a contract, however. And this, of a contract,
Right.
of a contract provision. And you're correct, you enumerated, Your Honor, the 10 number paragraphs of this contract. And not one says sandbagging, not one says concrete barrier, not one says floodgate, said dike. It's a one-purpose contract, which is why, and I want to get to Judge Harris's points about preemption in a moment, that is why it actually is a condition precedent. Condition precedent is an XY proposition, the way I dumb it down so I understand it. If no X, there can't be Y. Well, the X was the building of the dike. So back to your point about substantial performance, if X didn't happen, there is no Y to perform. And it's not hyper-technical, Your Honor, in the sense that this is happening. In fact, not because of the contract. Actually, as we speak, there are conversations underway, not in the record, I admit it, whereby, once again, CSX is saying, hey, if you want to build this dike, go for it. Not under the contract. If you want to...
You just went to the whole basis of why I'm just wondering why we're still here. There's no way in the world the railroad wants to see this city flood, and you know what's happening in North Carolina. We just had a major flood there. We don't have no idea. Lumberton is square in Cape Fear, all down there. It is some horrible things can happen down there. This has been going on for decades, and you've been allowing them to do it for decades, and all of a sudden stop. With the legal arguments, it has a lot of force to it. You prevailed, but it just seems to me, just out of public concern, you would settle this thing and not suffer another opinion coming from this court. We're not trying to lessen our work now. We're going to give you an answer. I'm going to tell you that right now. I don't know how it's going to come out. But that's a real concern here. I really thought when this case went back, my head went to, there's no way in the world we're going to see this case back because there are good people down there. You're running in a nice place, and it's a very strategic situation. Simple solution seems like to me. Simple in terms of, how this is done. Now, how you pay, I don't know about paying for the dike, whether it's state funding, federal grants, or railroad. That's out of my jurisdiction, but, developing a means so that this won't happen, because it's not like they want to use it for fishing or something like that. They're saying, we want you to do this so that the people in our city will be protected and will be safe if a flood, and floods have happened. You had 2 hurricanes come through there, and I unfortunately am of the belief, having lived in North Carolina for virtually all of my life, I know daggone well there's gonna be another hurricane coming to North Carolina, and Lumberton is one of those spots where they come to with some frequency. So you're telling me there's something being done and there's a possibility. Is that what you just said?
Well, I'm saying 2 things. I'm saying this is a harrowing circumstance. There is no question it is devastating. And the business of the railroad is that floods occur.
But you're making some effort to work something out. Something. It's not part of the record. Just for satisfaction, it seems like it's just the right thing to do.
What is part of the record? What is part of the record is that for 46 years, CSX has in fact done sandbagging CSX has in fact cooperated with the city and the drainage district whenever that is its intent, because it's in the business, like you said, Your
See,
Honor,
that's a
of flood
reliance thing.
control.
Once you allow someone to do something for 4 to 6 years, when you're gonna stop it, how much notice did you give them? You didn't wait until, you kind of wait till the hurricane came to tell them. I mean, it seems like if you're gonna stop something, you wouldn't wait the hurricane season. You tell them well in advance, if a hurricane comes in 6 months or a year from now, if you don't have those dikes up here, we're not gonna let you do this. Did that happen here?
Not in that, there's ongoing constant conversation between the railroad and local government. Notably, they have not sued. Notably, they are not unhappy. Notably, we're not here because of them, the parties with actual standing. That's not an issue. There is the cooperation that you are describing. We're only here because non-parties to the contracts are wanting something different. And I can't speak for them, but to Judge Harris's point, this is direct quote, direct regulation of the railroad. You found that on other claims in what I'll call Edwards 1 in 2020. And it can't be less, it can't be.
I'm sorry, counsel, what case did you just say?
Oh, sorry, well, I'll call it Edwards 1. Your.
It's a tort law.
Exactly, that's right. On tort claims, that's right. And I'm not saying, you didn't address the contract issue on preemption, but in the tort claims, Your Honor said this was direct regulation of the railroad. Well, when the same remedy is being sought, the same action is being.
That doesn't flow, does it? Because state law imposes duties under tort law. So it makes logical sense that if the state, if state law imposes some duty on the railroad, that could be an interference. That's a whole different kettle of fish than you agreeing to it in black and white and saying, just because, the effect may be the same, I grant you, but the issue to me seems to be where does the duty come from? You've agreed to the duty. You said, I'm in, I want this, I'm gonna make money, we're gonna keep going back and forth, and now you don't, I think you have some stronger, arguments contractually. I think your preemption argument, I can't imagine that you get to say, I'm a party to this agreement, I'm enjoying the benefits from years, and when I wanna, when the other side wants to, I know it's third-party beneficiary, so we're a little in that world, but when the city wants its part of the agreement, you say, no, I can't do that, that's regulating me, that's unbelievable.
Because in 1978, Your Honor, there wasn't a termination act, there wasn't preemption, and that was the way parties, I will say regulated themselves in 20 years before Congress decided that's not how we want to create a nationwide system of rail operation management. That is what happened. And by the way, there was no benefit. Seaboard, not CSS, got not a single benefit from this agreement.
That would mean it's not enforceable. There's no consideration. Did you make that argument?
We did not. We're not. I'm simply responding to your point, trying to be responsive, Your Honor. But the point is that the reason we studied you the Sabri case, the Wiedemeyer case, your own Alexandria case, which from the Fourth Circuit, which admittedly is not a contract case, but it's a permitting case. And the thread running through all of these cases is whether by contract, especially 20-year-old contracts, but whether by contract or by ordinance or by permitting, when you give a local authority, a local city manager or city council, the right to be the Surface Transportation Board, basically, because that's what's happening here, let's not forget. As you recited correctly, the contract, what happens here is that on its own, all by itself, the city of Lumberton decides one day, I see an, quote, imminent danger. And if that happens, it by itself gets to, and this is a quote from deposition testimony, close the railroad. and then it doesn't reopen. It doesn't reopen until that same city manager says, okay, you can open it. And while that is happening, what the undisputed evidence, on all 3 points, by the way, the record is undisputed. This is not a clash of evidence. What the undisputed evidence is that therefore hazmat materials can't get to the Port of Wilmington. That means that our StracNet system, I couldn't say that word until this appeal, that it's the Wilmington subdivision is part of our national defense. That's what StracNet is. The city manager doesn't have to think about StracNet. It doesn't have to think about the hazmat materials that can't move. It doesn't have to think about talk about burden, the possibility that what happens if other local authorities arrogate to themselves the very same right to be the STB, where we've lost the national uniformity that in its wisdom or not, Congress decided it wanted in a preempted world. And in every single case, and we've cited you about 6, Green Mountain in the second, your case, Alexandria. In every case where there is discretion in a local authority by permitting, by ordinance, or by contracts, in every one, either express or implied preemption is found. By the way, before I forget, because I wanted your question answered, so my colleague, Bill Cash, phosphate was an implied preemption case, just so you know. And it makes the same point. The reason phosphate was of no concern is because it wasn't telling the railroad how to run the railroad. The phosphate case was about money. It was about a railroad sort of bummed out that it wasn't liking its money deal. And what the Fourth Circuit, I think correctly, I was in that case, said was, courts are good at that. That's not trenching on the role of the federal authority, the STB. So that's why the cases that my colleague is citing make our point. Please.
I understand your
Please.
preemption argument. I want to move to the third-party beneficiary argument.
Please.
And I've looked at the cases that have been cited. Do you agree that North Carolina has embraced the restatement second of contracts in its contract law?
On this piece, yes.
Okay. Are you familiar with the illustrations that the restatement has about third-party beneficiaries?
I've read some, but I cannot commit that, Your Honor.
I appreciate that. I mean, I just looked into it, and here's I'm going to read something.
Please.
And I don't, I'm not trying to spring this on you.
Sure.
So if you need time, to think about it or don't have an answer today, that's fine. But the illustration 10 to section 302 says this is a third-party beneficiary situation. It says, A, the operator of a chicken processing and fertilizer plant contracts with B, a municipality, to use B's sewage system with the purpose of preventing harm to landowners downstream from its system. B obtains from A promise to remove specified types of waste from its deposits into the system. C, a downstream landowner is an intended beneficiary. That's a lot. Now, that's probably unfair, but just hearing that, do you have any initial reaction? It sounds kind of similar to what we have here to me. And do you have any initial thought as to whether it is or it isn't?
If I heard you correctly, Judge, and forgive me if I didn't,
No worries.
the difference there is that the downstream, the parties to the contract had in their consciousness, there was evidence of intent of helping downstream landowners.
Yeah.
And I concur with that. The key, as Your Honor said, in Edwards 1, was evidence of intent. And recall that all the parties must intend something. And what is that something? It's actually not even just to benefit X. The intent that must be there in the evidence.
So if that's right, counsel, if we have gobs of evidence that the city intends to benefit the residents who brought this case. Let's assume the record is undeniable on that.
Okay?
And the railroad says, look, there's an internal document that says, I know the city wants to help the railroad, these residents. We don't really care. We just want to keep the railroad going without any interference. I know that's not factual here. But is it your belief that in that situation, there's no third-party beneficiary?
What Materan's,
Is that a yes? Just say yes or no.
yes, yes, as harsh as that may sound, what's crucial is intent, not just to benefit. It's intent to give somebody else a contract enforceable right. As Materan said, the North Carolina Supreme Court, in that case, the only beneficiaries contemplated were the parties to the contracts themselves. So the answer is yes. And let's recall thousands of pages of documents, 20 depositions. It wouldn't have been shocking to find some evidence that the Seaboard intended to have someone else be functionally a contracting party. There's none. All the evidence the other side cites, and I understand that, was the city wanting to do its job. Because as Judge Wynn said, this is a harrowing situation. It is harrowing. But what there is not in this colossal discovery record is one whit of evidence that CSX, Seaboard, said to itself, I want to do more than honor my contract. There is intent that it wanted to honor its contract to let government come on our property and build a berm. There is none that it wanted to the annotation in their statement that it wanted to benefit the downstream people. Because after all, and I know I'm out of time, I apologize. You know, as Judge Cardozo said in a case that Your Honor sometimes cite, every public works contract, or most everyone, does benefit people. That's their nature. It's just even more than that for third-party beneficiary status.
Take your time.
I hear you in the case you mentioned, what is it, Materas?
Yeah, it's 268, you're right, 268 North Carolina 1.
I'm familiar with that. That's an interstate. And yeah, sure, the interstate benefits people who drive on it. That factually at least seems different than this, when, you know, everyone, it's just common sense who's going to benefit from it. Now, I hear you, you know, maybe that's not enough.
No, we're actually saying the same thing, Your Honor. We're saying the same thing in that I wasn't citing Materan's because it's factually alike. You're right. In that respect, they're not. I was citing Materan's to address your question of what has to be the consciousness of the parties. And what the highest court in North Carolina has said is it's got to be a desire by all of the parties to benefit the beneficiaries that are identified.
All right.
Nothing further, Your Honor.
Mr. Winkleman. Mr. Cash, you've got a few minutes.
Well, to pick up where we left off, then, I think we can infer that CSX and its predecessors did intend to benefit the class of residents at issue here. And we did put in evidence, including testimony from CSX's corporate representative, documents from the 1970s, testimony from the city and the drainage district about what the parties intended. And that was sufficient evidence to surmount summary judgment. And
Can I ask you, is it your contention that this evidence shows an intent to confer upon the plaintiffs a right to sue on this contract, or that you don't actually need that? It's enough if it was intended that they would benefit from execution of the contract?
I think it's enough if they would benefit from execution of the
You
contract.
don't think there has to be an intent to confer a right to sue?
No. And I think,
I mean, aren't there some cases saying there does have to be?
well, if the beneficiaries are intended to benefit from the contract, they should be able to enforce the contract the same way as the contracting party, the city. I think it's clear from the evidence that we put in front of Judge Boyle that everyone on the scene knew that the whole point of the Lumberton levy was to protect this specific area of town. And everyone knew that the levy would not work at all if the gap at the top of it wasn't closed. And that's why the federal government required the city and the state, the state and the drainage district to go forward and get the tri-party agreement in the first place. The whole point of getting the promises from Seaboard Coastline was so that they could breathe life into this levee system, which otherwise simply wouldn't have worked at all. And that is clear evidence that demonstrates that every party to the TPA intended to benefit this class of residents.
But if I thought that you needed an intent to confer a legally enforceable benefit, you're not suggesting that there's evidence of that here?
We're not suggesting that. When it comes to the condition precedent argument, I think the only thing I would really add is that there simply was not a material breach of the agreement. Even if there was a condition precedent requiring the city to build the dike, I don't think you can argue that it was material because it didn't impact CSX. It didn't cost CSX anything. The city's not building the dikes did not change anything about CSX's operations. And to the extent that there was an impact on railroading because it was a few extra days to put in that dike, that should be viewed in light of the benefits that CSX would have received from actually performing under the TPA, including the fact that closing.
But that argument, if we were looking at did the Railroad act reasonably, that might be a compelling argument. And it may still work under your contractual claim. But it seems to me if you're going to claim you want a benefit to a contract, the contract says upon notice, the railroad must let the city close a gap between an earthen dike. That's what the contract says. It doesn't say the railroad agrees to let the city put up a temporary structure that's not an earthen dike, and because it kind of serving the same general purpose. And that feels technical to even just articulate it that way, but I just wonder why that's not the way we look at it.
Because I think the answer is in interpreting whether there's a condition precedent, you look at the whole circumstances surrounding the agreement. And I think in part, the fact that CSX did perform under the agreement, did permit blocking of the crossing at one point, and never withdrew from the agreement for 40 plus years, when all it had to do was send a letter, is evidence that it's not simply actually a condition material to the performance of the contract. I believe my time has expired, and I thank the court.
All right. Thank you, Mr. Cash. Thank you, Mr. Winkleman. The court is going to recess sine die for the week, and we will come down, greet counsel. I reiterate that we have business along with a public entity, in which I don't think there's animosity in terms of wanting to do well. If there's a glimmer of hope that you're going to forego the need for us to do something, we will do that. We're not going to wait, so, because this court does not wait to issue opinions. So if you're going to do it, sometimes after Christmas, I'd jump on that. Court will now be in recess, sine die.
This honorable court stands adjourned, sine die. God save the United States and this honorable court.